All right, welcome everybody to the Vocational Science of Freedom Saturday night Civics and Sovereignty class. And tonight we'll be covering Class 8 Docs and Links, which is land rights and title. And we'll be going over a document that covers the Practitioner's Guide to the Federal Color of Title Act. And in this, I'm going to show where the feds kind of came over the top and turned around and created this color of title, the capacity for people to get color of title where there were discrepancies in who owned the land. And this particular act goes back to, I believe it wasn't until 1928, around March 19th, 1928. So let me scroll back up here and we'll give you an introduction. And I'm going to be going through this in a way where I'm going to be kind of discovering what's going on in this document with you guys at the same time, because I've read over this once, but I haven't double checked everything in it, meaning I haven't looked up I haven't looked up all the acts, but what I'm going to be doing is kind of giving an overview as to how I see what they did as best I can, as far as my knowledge is concerned regarding land title uh, and the law of allodial title. So to get started here, Americans' insatiable appetite for land and the nation's desire to reach from sea to sea culminated in the familiar historical phenomenon called manifest destiny. Congress passed many homestead acts to encourage settlement of the West, and so public land, or what was thought to be public land, became settled. So the homestead acts came first. So that's just a historical note. So whenever you're doing research into any subject, whether it be this being land title, or whether it be any other subject of law, you always want to go back as far as you possibly can to find the oldest laws first, and no matter where that may be, because when you're talking about common law, of course, you want to go back to, you basically want to start at the Magna Carta, even though you can technically start before the Magna Carta when you're talking about English common law and the various different courts. But when it comes to allodial title in America, you need to go back to the start of where each of the land laws were passed, what the common law says about land title regarding the adjudication thereof, as far as who owns what, and how title is passed by lawful deed from one man or woman to another, and then work your way forward, because when you get the timeline set up correctly, then you can see where the attorney has come in and altered things, or they wanted to set up entire systems that altered things, like we covered the last time with covering land title, the last class that we had when we went over the entire Torrens registry system, right? Like when did those things come into existence? So for this, one of the things you do want to go and check out is the Homestead Acts first. Okay, so just to give a note about that. Okay, and so the public land, or what was thought to be public land, became settled. Okay, to continue, yet not all newcomers to the West felt they had settled on federal land. Some had purchased their land from the territories or states. Notice that, lowercase s state. Others bought the land from previous owners, and still others had lived in the West for many years before the first Anglos ventured their way. Those newcomers and prior residents, for the most part, had evidence that they owned the land. In most instances, the evidence consisted of a deed. Now, a deed is something that transfers title of land from one to another. Moreover, they had cultivated or made their valuable improvements on the land, meaning they put up houses, they put up barns, they planted trees, they grew crops, whatever. When the government began surveying the public land to ascertain its boundaries, some of the landowners who had no idea that title to their lands was vested in the United States government were ordered to vacate and suffer the loss of home and livelihood. The more fortunate could claim land titles under one of the various Homestead Acts, but for many others, the only alternative was to seek private bills in Congress. There's a little note in the bottom here that I want people to pay attention to so that you understand what's the difference between a private bill. All legislative bills which have for their object a private interest as distinguished from a community interest are private bills. And that's from Black's Law 4th edition. Now, when, and you, anyone, any one of us, can seek a private bill from Congress if it deals with something with the feds. You can also seek private bills on the state level if it deals with something with the state. And this is something that I intend to do more research in, because there are a lot of private bills, including some very interesting ones, like the private bill that Stark had done for his multi-billion-dollar award against the United States through binding arbitration. And when we get into the research of doing this, I will definitely set up a committee so that people can join and help to research how to properly make private bills, both on the federal side and on the state side. Because this is something that we have the power to do, it's something we should be doing, and it's something that people have done for a very long time. So, to continue. Addressing this serious problem, the Secretary of the Interior, Hubert Work, wrote Senator Gerald Nee, chairman of the Committee on Public Lands and Surveys, requesting remedial legislation. Senator Nee quickly responded, March 24th, 1928, only 9 days after the Secretary of the Interior wrote the letter. And I'm going to skip this little part here and just go straight to the letter. So basically what he wrote was, he said, Dear Mr. Senator Nee, numerous cases have arisen where lands have been held and occupied in good faith for a long period of time under a claim of title found defective, and in many instances value improvements have been placed upon the land in the belief that the title was good. Existing law makes no adequate provision for the protection of such rights. Now, I'm going to pause right here. Existing law, existing statutory law. He didn't put the word in there, but that's what he's talking about. There was plenty of adequate law regarding the common law as to how to try title. But that's not what he's talking about. He's talking about making statutes for it, okay? And as a result, many such chains have been submitted to Congress for remedial legislation. That's the private bills that I was just speaking of above. I am of opinion that a general act should be passed authorizing the Secretary of the Interior in his discretion to issue patent upon such claims upon payment of a price that will be just alike to the claimant and to the government of the United States. So, I mean, what was this? It was a way for them to generate more money and to create patents, or to recreate patents in places or over places where the patent had probably already been there. Okay, so just make a note of that they're making money here. I have drawn and submit for your consideration a bill having for its purpose equitable adjustment of such claims. Now I'm going to pause here again. A bill having for its purpose equitable adjustment of such claims. When there is a remedy inside a statute, it's automatically under the jurisdiction of equity. Okay, that's what you're talking about as far as equitable relief is concerned in a lot of cases, is that if there's a statute that has the remedy built into it, that's an equitable remedy. Okay. All right, to continue. By the Secretary of the Interior, it is believed that the bill, if enacted, will affect a useful purpose and relieve the Congress from considering many special acts for relief. The special acts for relief he's referring to the private bills. Okay. The introduction of this bill is respectfully requested. Yours truly, Hubert Work. Okay, so now let's go back up here. So that was the letter. Okay, so today the importance of the Color of Title Act. So only 9 days after he wrote the letter, they introduced the bill, which became known as the Color of Title Act. Today the importance of the act cannot be denied. That's attorney speak for we like it. About 1/3 of the total land area of the United States belongs to the government. Actually, it doesn't belong to the government at all. It belongs to the people as a whole, because the United States of America is a trust. Now, of course, by this time, the trust had been bankrupted, which, of course, was in the Civil War. However, it doesn't change the fact that the government doesn't own it. The people own it. And the government holds it in trust for us, which is why you can go on to government land still to this day and homestead on it, and then go and get an original land patent. And I don't even mean doing it through this act. I mean getting an original land patent from the original laws up here, which I mentioned regarding the Homestead Acts. Okay, you can still do that. There's a process for it. Even though I'm not fully learned in how to do it, I know it can be done because I know of people that have done it. Okay, so not until recently has the Bureau of Land Management, BLM, had sufficient funds to continue surveying public lands. After the Bureau has surveyed an area, many people discover that they are living on public land. Well, again, that entirely depends on whether they try the title on either an original land patent or whatever. Just the government saying that you're living on public land because the Bureau of Land Management decided to do a survey doesn't validate their claim. Okay. For example, in New Mexico, the BLM is in the process of surveying a narrow strip of land from Bosque, I guess that's how not sure how you pronounce that, Del Apache north along the Rio Grande to the Colorado border. The BLM estimates that there are more than 1,000 families residing on what may be public lands. See, they use the word residing. They didn't use the word domiciled. Those families either will be able to meet the requirements of the Act and thus gain title to the land, request the Congress to approve a private bill, or be required to move. So what does that mean? It means that you can still do a private bill. Just because this act was passed didn't mean that they got rid of the capacity for you to go and put in a private bill to Congress for the title. Okay, so to continue, a thorough understanding of the act will ensure both government and claimants a peaceful means of resolving title to land. This comment has been written to provide that understanding to the practitioner who may be called upon to assist claimants under the act. What is the Color of Title Act? Simply stated, the act provides for a procedure whereby title by peaceful adverse possession may be acquired against the United States government. Well, guess what? That basically existed in the Homestead Acts. It's the same thing. But now they're talking about that it's adverse possession. Well, in that, when you're thinking about it in that light, what the U.S. government is claiming is still under their hold or is still under trust to them, and you might be sitting on it. This is where that idea of adverse possession comes in, that you're coming upon and sitting or have been sitting on what they consider to be the public land, and you haven't done what you probably need to have done regarding the common law to already have taken care of that, whether it be a private bill or whatever else. Oh, you guys said I'd like the homestead. Well, then find government land. As it said, and just above here, what does it say? 1/3. I think it said 1/3 of the land. The public lands that are, say, reserved for national parks. Obviously, you can't homestead in a national park. But I believe, and again, don't hold me to this because this is the kind of stuff that we need to look up and research, that public land, public forests are all can still be homestead. You can still go and homestead on them and get an original land patent. And it's not 20 years kind of thing. I believe it's only 7. But again, don't hold me to that. These are all kinds of things that we have to research. I have a pretty good idea about how all this works, but this is the reason, this is the exact reason actually why we're going over documents like this, is to pull out more information, find terms, find acts, find whatever knowledge we can, and then put it together so that we do know what is exactly going on and exactly what does apply and what doesn't apply. All right. So that might sound anomalous to those who remember the first year property law. Traditionally, adverse possession is a statutory declaration allowing an individual to seize another's land with the hostile intent to deprive the true owner of title to that land. Okay, great. If it was actually one of the people that owned it, this little sentence would be true. But it's not. If the U.S. government is saying or claiming that they are holding it, they don't own it. They're holding it in trust for us because it's the people that own it as a whole, until you say, okay, I want this piece for me because I require a domicile and I require to set up a homestead, right? So Moreover, adverse possession traditionally did not apply to sovereign lands. Well, then again, these lands, until one of the people claims them, are not sovereign. But again, we should probably take a look at whatever this particular little annotation is, number 12 here, and see what kind of case they're actually talking about. Because my guess is the way they use this in this sentence is actually not the proper way to use that term. Because sovereign lands is one of the people that holds land in allodial title. That would be sovereign land. The government holding in a trust, I do not under any circumstances consider that to be sovereign land, and by the law it really is not. It's the incorrect way of the attorney trying to make the government seem as though that it has some sort of sovereignty over the lands. It doesn't. It only holds them in trust. Okay, to continue. The Act permits claimants to purchase up to 160 acres of land from the government if they were unaware that title to the land was originally vested in the United States government, and when certain conditions are met. Conditions to be met depend on the type of application, Class 1 or Class 2, filed by the claimant. And then it gets into the applications. The process begins at the local land bureau. All of this stuff they're talking about here deals with how to go through it through this color of title land act, right? This is not how you would go through it if you were doing an original land patent and an original homestead. Okay, here's an interesting part of this thing. A Class 2 application should be filed when claimants or predecessors in title have established a chain of title commencing before the 1st of January 1901. Huh? Now, what the hell happened in 1901? Don't know. They didn't mention it. But it's certainly not when this color of title act was passed, because we're talking 1928. So, see, it's little weird things like this. Like, okay, before the 1st of January, well, what does this date have anything? Why is this date important? What was passed or what changed in 1901? Notice how the attorney doesn't tell you, right? But it's little things like this that you have to look up and you have to go back and double check and see what changed, right? Okay, so anyway, continuously have paid taxes on that land in accordance with state law and have held the land in good faith. Right. So under this act, you have to have been continuously have paid taxes on the land. Well, what if you held the land in allodial title and you never paid taxes on it? Well, okay, that would be different then, wouldn't it? Right? Because when you hold allodial title, you're not supposed to be paying taxes to anyone. Because why would you? You don't have to pay taxes to a landlord because you own it. Class 2 applicants must file an additional document, blah, 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 which lists all tax payments, right? So if you've been a good little slave, right? So the only way that you're going to get equitable remedy through a federal statute is if you've been a good little slave already, right? Makes sense. Okay, so to continue, the advantage of Class 2 title is that holders of such title also may obtain title to the mineral estate. If you held a allodial title, you'd own the mineral estate already, because a allodial title includes everything to the center of the earth and all the way out into space. All of it. Including the capacity to mine and take from the land whatever the hell you see fit. All right, to continue, nonetheless, Class 2 claims, even if all their conditions were met, are completely at the discretion of the Secretary of the Interior. Interesting. So only if the infant is given it by the Secretary of the Interior, right? So this isn't something that you control. Just pay attention to this because it's important. Every single time that you're asking for benefit or you say, oh, please, Daddy, may I, are you acting in your sovereign capacity? No, you're not. You're submitting an application for permission to do something. Well, only slaves submit, okay? All right, to continue. While the fulfillment of Class 1 requirements automatically confers title to the claimant. Okay, great. In the event claimants are found to be eligible, the BLM appraises the land at its fair market value, but deducts any increase in value resulting from improvements made by the claimants or their predecessors in title. Next, the determination is made of whether it would be equitable to charge the claimant the full market value of the land, and if not, then to reduce it to just reasonable price. So what are they doing? Again, like I said, they're just trying to, this is Congress trying to make money. trying to resell stuff that people probably already owned anyway, right? However, the government cannot sell land less than $1.25 per acre. That's okay. That's actually in USC. So they have all these USCs in here. 43 USC. Looks like most of this is under 43. So all of this would be interesting to look up and connect it back to. All right, to continue, claimants are required at their own expense to publish notice of their claim once per week for 4 consecutive weeks in a local newspaper. That's funny, because that's exactly what we do when we do the Declaration of Allodial Lands. We publish it in the newspaper for 4 consecutive weeks and say, this land is now allodial by the decree of the sovereign that owns it, who holds lawful title, meaning the original land patent. And if anybody has any questions about that, then they can bring it up. If not, then it stands. So notice that they're doing exact same thing that we are doing or have done in the past, but except we're doing it from the standpoint of allodial title, and they're doing it from the standpoint of color of title, right? All right, prospective adverse claimants, meaning the adverse possession claimants, are put on notice to file their objections with the state director of the BLM and to serve a copy on the claimant. How adverse claims are to be settled is uncertain. Well, wonderful. So let's make this whole entire act and then say, well, we don't exactly know how we're going to settle this. What, at the discretion of some black-robed priest of El? Probably. Anyway. But it appears that the government cannot issue a federal patent in such cases until the claim has been adjudicated in court. Well, no shit. Because it needs to be a court of record. Because technically, no title to land can be settled in any court but a court of record. Meaning a common law court, right? A court that proceeds according to the course of the common law. That's something that I've read multiple times in various different treatises on land that obviously they're not going to state in here. Maybe this little part, no, that has to do with the Board of Appeal, Land Board of Appeals, so whatever. No, but anyway, that's an absolute fact that I know. That true allodial title can only be tried in a court of record. Okay, litigation areas. Although the act seems fairly straightforward, it does present some potential problems, clearly. Practitioners should recognize that failure to provide all of the relevant information required by statute or regulation constitutes adequate grounds for rejection of the application. Great, this is attorney work product doctrine. That's what that is. You have to do everything that the attorney says, and if you don't get it exactly right, well, then you're not a good infant. So what does that require? It requires that the infants go and hire attorneys to do all this shit. Okay, what if I just want to bypass the whole damn system? All right, then I claim the forever clause in the land patent, in the original land patent, and do a declaration of allodial lands upon it. To continue, moreover, since the burden of proof is on claimants, well, no, the burden of proof is on anybody else once you do the declaration of allodial lands. You say, this land is allodial. I hold allodial title to it. Does anybody question it? Does anybody have a higher claim? No? Great. Mine. Practitioners must understand the problem areas in the Act in order to represent effectively clients who are claiming under the Act, right? This is, again, we're attorney work product doctrine. You're talking to the attorneys here. All right. Color title. Applications under both Class 1 and Class 2 are required to be accompanied by evidence of color of title. Evidence by evidence of color of title. Is color of title title? No. The statute and regulations have not defined color of title. Well, isn't that just wonderful? Isn't that just special? The statutes and regulations have not defined color of title, yet under the Act they are required to be accompanied by evidence of color of title. How can you evidence something when it's not defined? Again, attorney work product doctrine, we're going to give everything to the black robe priests of El and allow them to do whatever the fuck they want. This is what the attorneys do. If there's ever more blatant, clear evidence of it, just in these 2 sentences alone, I've never seen it. Because that's pretty much in your face. But the Department of the Interior has taken a position on its meaning. Well, who cares? The DOI accepts any instrument which on its face purports to convey title to the land in question. Oh, wonderful. So claim jumpers and any filthy attorney can come in and just create something which purports to convey title. and then they can go get it. Right. Problems with color of title requirement arise in 3 areas. Well, I'd say more than 3, but let's see what they're talking about. One is inadequate land description in the instrument. Well, that would qualify. The instrument on its face does convey land, but the description is ambiguous. Okay, fine. Another problem area is certification of the chain of title. Right. Well, certification and also authentication and acknowledgement. The acknowledgement of passing of title from one to another to another to another in the land record is a requirement. If one doesn't acknowledge the transfer from one man to another, all right, this is how it's supposed to go. One man sells land to another man. That man then takes the deed and is supposed to go down to the public recorder's office, the land recorder's office, and acknowledge the deed, acknowledge the transfer of the deed. That's what you're supposed to do on the land record. And yet nobody does it. And nobody does it with even with their homes. And that's a problem. You need to acknowledge the transfer of the title, which is something that is done in the Declaration of Allodial Land. After you file it, you go back and you acknowledge it. To continue, state laws may prevent a county assessor or county clerk from certifying the chain of title as correct. Well, okay, yeah, I suppose if there's a lot of errors in it, I guess that's justified. And finally, claimants may be the owners of the property yet unable to produce an instrument or document evidencing title. Okay, fine, yeah, that would be another problem. Inadequate land description on the face of the instrument will not suffice to grant title under the Act. The description of land must be made with a reasonable degree of certainty to meet color of title requirements. Again, this is all about the Act. However, ambiguous descriptions may be cured by extrinsic evidence. In some instances, claimants may have a deed so ambiguous that even extrinsic evidence will not cure it. Or claimants may not have a deed. Well, if you don't have a deed, then just get out of my face because you don't have anything. Claimants in either of those situations are not entitled to the benefits of the Act. Nonetheless, the benefits of the Act, right? So what are you doing? Taking a benefit if you use this Act, right? Nonetheless, it seems unfair to force claimants off land, especially when they truly believe they own the land. Well, exactly. If they hold allodial title, they're holding the land patent, and they show a abstract or title going back, then they do own it. There's nothing they can say about it. Now, again, that would be where you'd take your private bill to Congress and say, look, I own this. Does anybody have a higher claim? No? Great. It's mine. A study is underway to assess defective color of title problems in New Mexico. The result will be very important in determining future cases. And again, remember, this is quite a ways back. Oh, actually, this was probably in 1980 because, yeah, this was written in 1980. So that would be kind of a semi-current issue for New Mexico. Okay, to continue. A proper county official or an abstractor must certify the chain of title as correct. Right, because you used to get abstracts from abstractors. Now it's getting to be more and more difficult to actually get a proper abstract for a particular plot of land. They're trying to wipe out the entire land record. Let me make this very, very clear to everyone. They are trying to wipe out the entire land record so they can push through Agenda 21 and all of the rest of the New World Order bullshit that they want to take over this country. And all of the rest of the world, truth be told. But since we're talking about American land law here, this is what they're doing. And the beginning of it was this act, and then going into the Torrens registry system, and then going into what they're now doing, which is erasing the land title records and saying, oh, we can't get an abstract. We don't do abstracts anymore. Huh? How the hell do you know who owned it back, back and back and back and back and back and back? I mean, there are land records that you have in Europe that go back hundreds and hundreds of years. Oh, and you're telling me that's not valid anymore. Why? Because the attorney wants to create a system where nobody knows when anything's going on and you have to hire an attorney in order to have any remedy? Right. Yeah. Gotcha. Wonderful. To continue. A county official may believe that he does not have the state authority to certify the form. In such a case, a claimant would need to resort to an abstractor. Abstracts are expensive, and for some claimants, this expense may present a significant barrier. Well, too bad. There should have been an abstract given to you at some point in time when the deed was transferred. Right? That's when they're supposed to be transferred. You're supposed to transfer and give at least a copy and present a copy of the abstract from one man to the other when they transfer the deed. But again, listen to the attorney's language. Abstracts are expensive, and for some claimants, this expense may present a significant barrier. Well, do you have to require it for law? Yeah. So get it done. Again, this is the attorney trying to appease to you to say, oh, well, we don't want, we should change this. Why? Oh, that's right, because abstracts actually show every single holder of title, going all the way back to the original land patent, which is where you'll find the abstracts start at. The first thing in any abstract needs to be the original land patent, signed by whatever president to whoever sovereign they gave it to. That's where the abstract needs to start. And if an abstract does not start with the original land patent, you don't have a full abstract. That I'm sure of. All right, to continue. Claimants in this situation would contact their local state representative, who in turn may request an opinion from their state's attorney general office on whether the county official's duties must comport with the federal regulation. Well, yeah. Another approach would be to have the BLM do the title work. This solution would require legislation and funding. Moreover, to have BLM obtain the evidence and then rule on the claim places BLM in the conflicting role of protecting the government's interest on the one hand, and at the same time representing the claimant. Right. Just why you should get a private abstract done and then double check everything and then stand on it with a declaration of allodial lands. Good faith. All right. Good faith is an essential element for any essential claim made under the Act and is perhaps the most litigated requirement. Good faith in adverse possession requires that the claimant honestly believe that the land was owned by him and that the claimant did not know that title to the land originated in the United States. Good faith challenges arise in two situations. Was the claimant unaware that title to the land was in the United States? Did his predecessors in title know that title is in the United States? Well, how do you ask a dead man anything? You don't. And how do you prove a negative? You can't. So both of those arguments are ridiculous on their face. Before discussing the ramifications of good faith, it is appropriate to clarify whether good faith is to be measured by an objective or subjective standard. If good faith were measured by a subjective standard, then all that would be required for it is for the claimant to state that he honestly did not know that the title to the lands was in the United States. Exactly. That would be the end of it. The government would then be placed in the position of attempting to refute that assertion. And again, you can't. So how do you refute when somebody says I didn't know? How can you prove that they did know? You really can't. On the other hand, if the standard were objective, then the government would be permitted to present evidence on the question as to whether a reasonable person under the circumstances might believe that title to the land was vested in the United States. That's just attorney work product doctrine bullshit. Well, he should have seen this, and he should have done that, and he should have known this, and he should have known that. Great. Was any of that ever presented to him when he was way out in the middle of the West building his house? Nope. Anyway, a series of administrative determinations has held implicitly that the objective standard is to be applied to measure good faith. In Joe versus Lena versus Sanchez, the DOI administrative law judge applied the good faith applied the good faith standard. Sanchez's based their claim on chain of title originating in 1905. In 1962, Sanchez's inquired about obtaining a grazing permit on public lands, and the government issued permits to them in 1965. 2 years later, the Sanchez's purchased the land that may have included the same public grazing land. The issue before the administrative law judge was whether the Sanchez's knew or should have known that when they acquired the land in 1967, that title to the land was in the United States government. Since the evidence presented in the case did not address the question of good faith, the administrative law judge remanded the case for more factual development on the issue. Presumably, if it were found that the Sanchez's knew or should have known that in that 1967 land purchase included lands in the grazing permit, then they would not have fulfilled the good faith requirement. And again, you see how when they bring in these acts and they're trying to place fiction over reality, where you get into all this mess, which is exactly what the attorney wants. They want everything to be a mess. So only they get to determine what is and what is not the be-all and end-all of their own mess, right? That's the law merchant for you. That's the law merchant coming along and selling you his law because you need to buy it. Really, there really isn't any reason, but that's what it is. That's what the law merchant does. Comes along and sells you his law. He's going to sell you on his law. No, I'll just stand on common law, thank you. Don't need to buy your law. All right, to continue. As noted above, the Act requires that claimants must have brought the land in good faith, not knowing or having reason to know that the title of the land was in the United States. Thus, claimants who acquire the land knowing the title is in the United States government cannot rely on the good faith of their predecessors entitled to meet the statutory period. Okay, blah, blah, blah. Contrary policy, going to skip that. Good faith requirement, I'm going to skip that. All right, cultivation improvements. Class 1 applicants require either that valuable improvements be made on the land or that part of the land be cultivated. Okay, so this is about improving the land. Now, this part does actually go back to common law from the standpoint of proper metes and bounds and allodial title. That you have to improve the land. You can't just go buy it and then sit on it, or go buy it and then do the speculation, land speculation thing, which is exactly what George Washington was very, very good at, by the way. He made a tremendous amount of money in land speculation, where he'd go out, do the surveys, whatever else, acquire it, and then wait for people to move out that direction and then sell it to him at a much higher price compared to the $1.25 per acre that he bought it from the government, right? He was very well known for that. But anyway, what constitutes a valuable improvement or cultivation, and at what time can they be made to satisfy the requirements of the Act? Well, whatever. Not even going to bother to get into that. Skip it. All right, withdrawals. Although the Act applies to all public lands, it does not apply to lands that were withdrawn or reserved from the public by the Secretary of the Interior, by his delegate, or by Congress. That's where you get into national parks and that sort of thing. Or areas like lakes or dams, I think, are also in there too. Like Hoover Dam would probably be in there. I don't know if national forests necessarily apply there. But I would say that certain national forests probably do, like probably Sequoia National Forest, I'm sure, which I believe is connected to Redwood National Park, I think. Those wouldn't be able to be homesteaded because they're under federal protection. So that makes sense. Okay, so to continue, withdrawals may affect a Class 1 claim in three situations. 1, where the withdrawal takes place before the chain of title begins. 2, where the chain of title is initiated but the statutory period has not been fulfilled before withdrawal. And 3, where withdrawals occur after the statutory period of the chain of title is run. A Class 2 claim would be affected only where the land in question has been withdrawn before the chain of title began, because there is no statutory time period that need be met with respect to these claims. Exactly. If you can claim something back before any of the idiocy, meaning claiming the original land patent, then you bypass all this shit, which is basically what they just said in a nutshell. The DOI has steadfastly held that a color of title application will not be allowed for lands that was withdrawn before the initiation of the claim. For example, where the first deed in the claimant's chain of title is dated after the land was withdrawn, the application is rightfully denied. Yeah, okay, so that would be where they had withdrawn the land, meaning it put it into a national park, basically. So if they did that and then they tried to bring it, if somebody tried to bring a claim to it that was dated after they'd turned it into a national park, well, then clearly that application is rightfully denied. And I understand that. That makes sense. Because the national parks are places where we, the people, through government, through federal government, have said, okay, we want this set aside where we can all enjoy it, but no one gets to take any particular piece of it, right, for their own private use. I understand that. But the vast majority of the lands that are out there, like I said, are not federal parks. They're not national parks. They are just sitting there waiting to be homesteaded, basically. Okay, to continue. In Clement Vincent Trillion Jr., the DOA held when a Class 1 claim arose before the lands were withdrawn, the withdrawal does not preclude performance under the Act. Okay, wait, hold on. Held that when Class 1 claim arose before the lands were withdrawn, the withdrawal does not preclude perfection. Preclude perfection under the. Oh, what they're saying is that you still got to prove the fact that you could perfect your title before the lands were withdrawn, meaning put under federal control as far as the national park is concerned. Okay, that makes sense because you would still have to prove chain. You have to prove chain everywhere, so that's fine. When claimants have entered upon lands in question in good faith before the government has withdrawn the lands, the withdrawal will not toll the 20-year statutory period. Thus, such claimants may receive title to these lands under the Act. Okay, no, yeah, it makes sense. In the last situation, the withdrawal would have no effect because the statutory period was met. Therefore, once the chain of title has commenced before the withdrawal, Class 1 claimants are entitled to the benefits of the Act. Okay, yeah, right. Right, so they can claim it. So, strangely enough, under this part of this Act, someone could technically have a house in the middle of a national park, which, you know what? I think I've actually seen that before, truth be told. All right, so summary. The Color of Title Act provides a means by where individuals and their families who reside on public land under an instrument purporting to give title of the land may acquire good title to the land. It just says good title to the land. It doesn't say allodial title, but anyway. The requirements for Class 1 and Class 2 applications are relatively straightforward, but there are troublesome areas, which obviously they already talked about. Problems exist in determining what constitutes good faith, establishing an adequate land description, fulfillment of cultivation or improvement requirements for Class 1 applications, which, by the way, this fulfillment of cultivation or improvement, well, I'm not going to put the requirement thing in there, but the fulfillment of cultivation or improvement. That's the exact same thing you have to do when you do go and get an original land patent and you go homestead government lands right now. You do have to show that you've improved the land in some way, shape, or form. You know, you put a house on it, put fences up, you did crops or raising cattle or whatever, put up a barn, whatever it may be, right? You still have to prove that. And see, to make a more fine of a point about this, that was the exact reason why the BLM went out and pulled up and destroyed all of Bundy's watering troughs, because it was an improvement to the land. And they could prove that, and they could prove it over a period of over 7 years. And technically what the Bundys could have done is they could have demanded an original land patent on all of that land. So that's why the BLM went out there and ripped that shit up. Not that anybody was paying attention to that, even though I tried to tell them when it happened a long time ago. I'm like, at least I had a friend that was talking to him and said, look, this is the reason why they did that. You guys should just go and apply for an original land patent. Not through this act, but to just get an original one and do it properly through the Homestead Act. But anyway, that's water over the bridge, whatever, however you want to look at it. But the point is that that's what you have to do for an original land patent. You do have to show fulfillment of cultivation or improvement of the land, which the Bundys had. Okay, to continue. Requirements for Class 1 applications and the effect public land withdrawals have on claims made under the Act. The present interest by the BLM to survey the boundaries of the public domain emphasizes the need for practitioners to understand this admittedly arcane area of law. Well, it's not arcane if you go back and learn land law prior to their fumbling with it, fucking around with it. Go read a treatise on land title that, say, predates 1776, right? Go read a treatise on land title in England. They're out there. I have plenty of them. There, and anybody who's purchased my entire hard drive and who's a lifetime member, you have them too, because they're in the treatise folder. They're very interesting reads. And they, honestly, every treatise that I read on any aspect of law is always fascinating, because it teaches you, because most treatises always make sure that they do have a very, very good, long, laid out timeline as to when things happened, when things changed, when things started, so on and so forth. In fact, one of the most interesting treatises that I have on the hard drive, and that I've read all the way through twice because it was so interesting, was a treatise on the law of process, meaning due process, right? When is something considered to be valid due process and when it is not? And that goes to everything from the service of an original writ to the the local law enforcement, highest law enforcement officer of the county, meaning sheriff, to go out and serve a writ of execution for something that somebody demands back from somebody else, be it a cow or horse or whatever. If you go far enough back, even you have writs of execution to even go and get slaves. And I don't mean America. I mean, of course, it happened in America too, but I mean going all the way back to Rome. And what is and what is not considered good process or proper process or lawful process, meaning was the writ signed? Did it have the court seal on it? All these various different things that have to be properly done that no one cares about anymore because the entire Roman civil law system is running amok over all of us without any of us paying attention as to what needs to be done to fix it. That's the main problem. If you do not understand where the origins come from and where these things go back to, you won't see what the attorney is doing now. You won't see their agenda. But if you go back far enough, you can see the whole agenda, the whole thing's in your face. It becomes so blatantly obvious. It shines like a 1,000-watt light bulb in your eyeball. You can't not see it. But for those that have never gone back, it's almost impossible to see it because you have to go back before they started to fuck with things. And whatever that, Luciferian fuckery might have been, right? Like in some instances when you're talking about the administration of our estates, I mean, that goes all the way back to Rome and to when Nero burned Rome to the ground and with the agreement of the Senate. And then they brought in the 12 tables, which was a set of laws that said basically the same kind of thing that the Sesquique Viac said later on in 1666 in England. And again, this is just black robe priests of El doing what they do. That said, if you can't prove, your title as to this or that or whatever, then Caesar gets it. What did they do in the Sesquique Viac? Same kind of damn thing, except then the attorney got to, or the crown, which is just a corporation, got to administer it. Right? Unless you prove in an action to have been found to be living, the title is then revested. Right? But only is the title revested if you prove it in an action, which is why we prove it in a judicial inquest, a proof of life and proof of age inquest, because that is the proper way to do it. And all of these things are written down. Everything that I just mentioned that I didn't bring up, bring up to look at tonight about land title and about allodial title, it's all written. It's all out there. It's clearly in everybody's face. The point is to, keep doing your research, keep learning always, and keep finding little interesting tidbits of things like this. I would say that the first thing that you always want to do is go find the treatise on something. But then after you've read a treatise on something, go find a couple law reviews on the subject. And try to find law reviews as far back as you can possibly go, because it's not like these things weren't being written in the late 1800s. They were. This one just happens to be in 1980. But again, it's not that this wasn't useful, because it showed a lot of different things, but you have to know what you're reading too. You have to know how to read these things, and you have to see how the attorney writes them, which I mentioned in a few places in this document. And the more times that you go through these things, and the more times that we cover them in our classes, I'll always do that. I'll always make sure that I show you guys, see what the attorney's trying to do here, see what he's trying to do here, see what he's trying to do here, right? So you understand their agenda, because they do have one. And their agenda is to control you and to control everything through the Bar Association. So with that, I thank everybody for coming tonight. And tonight's been the Vocational Science of Freedom Saturday night Civics and Sovereignty class. And I thank everybody for coming, and make sure all you guys stay free and stay sovereign. And I'll turn off the recording, and then we can take questions and talk amongst ourselves.